This is an Eyewitness News special report. A verdict in the Sean Bell trial.
And a very good morning. I'm Ken Rosato.
And I'm Lori Stokes. A judge, Arthur Cooperman, in the trial of 3 NYPD detectives in the Sean Bell case, is in the process, we understand, actually has announced the verdict of those 3 officers that had various charges, including manslaughter as one of them, to reckless endangerment. We understand that the judge has decided not guilty on all of the charges.
For all of the officers. Let's go live prayer service. We now go to Michael Farkas, who is a legal expert who can kind of chime in on all this. What was this expected, do you think, Mr. Farkas?
Well, it's really not surprising to me. I thought that at most the judge was perhaps going to consider the misdemeanor reckless endangerment count against 1 or 2 of the officers. But really, the legal standard here is so tough to meet, especially when you have credibility problems with the witnesses. I'm not surprised at all.
So you really think that was a factor, the fact that these men did have criminal records at some point versus that of a police officer and what they deal with on a day-to-day basis?
It really is a combination. Even if the witnesses were a bit more consistent or didn't have the records that they have, it's very, very difficult to second-guess someone in this kind of situation, especially officers who are not rogue officers, mavericks, people looking for a problem. You know, the prosecutor was in the unenviable position here of trying to prove that these officers intentionally tried to seriously physically injure somebody. That's a very tough nut to crack. Civilly, it'll be a different story.
Yes, that's what I was going to say, because Kenneth brought that up a little earlier with N.J. Burkett about what recourse do they have, does the Bell family have at this point?
Well, historically, we've seen what the recourse is, whether there's an acquittal or a conviction. There have been multi-million-dollar settlements with the city in cases of a similar nature, and I think that's exactly what the family is going for now. They're set up for that, and it's going to happen in time.
We want to thank you, Mr. Farkas, and ask you to stand by as we go back to N.J. Burkett, who is in Kew Gardens outside.
Our legal analyst, Michael Farkas. Mike, when we heard Pat Lynch from the PBA talking about the verdict very briefly, and he said that for police officers, there's never any script on a day-to-day dealing with their various circumstances. But what this did prove to the NYPD is that when an officer is in that type of position, where there has been a loss of life, that in front of a courtroom, they get fairness. That kind of struck me as very significant. How about you?
Absolutely very significant. It's the same for the military, if you think about it. The police officers who are on the street, very often risking their lives in very dangerous situations, have to know that when they reasonably believe that they are justified in taking action, including using deadly force, that they're going to be backed up either by the department or by the court system. They have to get a fair shake. Now, that being said, the judge made a very good point, and this is the reason why I believe there's going to be a significant civil settlement here, because carelessness, while not criminal, is actionable. And really, in any operation, if you analyze it, there can always be things that could be done better. There's always some planning that can be improved, training that can be improved. That itself is not actionable. But if there was actual carelessness, if this operation wasn't properly planned, if there were risks that were taken that, while may not be criminal, but certainly should have been avoided or improved before they went into that situation, that is actionable. And those are the things that improve the system.
So carelessness is not recklessness?
Absolutely not. Recklessness is a very high standard. You have to consciously disregard an unjustifiable risk that either death or serious physical injury is going to occur. That is incredibly difficult to prove except under extreme circumstances, and the circumstances have to be such that a gross deviation from the standard of conduct that a reasonable person would have observed in that situation exists. That obviously was not proven here.
But at the same time, as you mentioned, carelessness does open wide the doors to a civil action. A civil action. In this case, the family has apparently acknowledged that they are very interested in pursuing.
That absolutely does. And that really is the way it should be, because if we, as a government or as a society, is not looking to look at ourselves and look at our mistakes, and sometimes it takes getting kicked a little bit by the civil system in order to improve it, then we really aren't doing our jobs as a society in protecting our public.
But you also have to look, for the average civilian, reckless behavior then is not the same as a police officer when they also are confronting maybe a charge of recklessness because there's such a differing case of individuals?
That's a cynical viewpoint, but it's not true, at least not as far as the letter of the law is concerned. The reckless standard applies to everyone.
Oh, okay.
It is a reasonable person standard. If you are in a situation and you are aware of a very serious or substantial risk that death or serious physical injury is going to occur, and you consciously disregard it and it's unjustifiable, then under a reasonable man standard, a reasonable person standard, you're guilty of a crime. But think about how difficult and what a high standard it is to establish.
Absolutely. All right, I'm glad that you were able to clear that up. We still have with us our legal analyst, Michael Farkas. And Mike, I don't know if you just heard the sound that came from Michael Palladino, the head of the DEA. When asked about the verdict, he referred to Judge Arthur Cooperman and said that he's a profile in courage, and then he went on to say directly about the verdicts, thank God. But I want to go back to the part about being a profile in courage, knowing the amount of pressure that the judge had to have had on him. Did it take courage for this to hand down these verdicts?
Well, I'm sure that if you asked him, he would not agree with that statement. He would say, as I believe, that he interpreted this in a very strict interpretation of the law. And as I've been saying, the standards here are very, very high, as they are in every criminal trial, but the concepts of recklessness and intent are very difficult to establish in a case like this, especially when you have witnesses that are not consistent with even themselves, much less each other. It makes a trier of fact have a very difficult time of believing that any kind of criminal act occurred. A horrible tragedy occurred here. Certainly it seems to me that it's civilly actionable, but I have to agree with the judge's decision here. With a strict reading of the law, it was very, very difficult to say that there's no reasonable doubt. And courage, if you want to interpret someone making a very, very difficult decision in a very high-profile setting, then sure, it took courage. But I think he was doing his job, and if you asked him that, that's exactly what he would say.
And that he was able to divorce himself, in essence, from the publicity of this particular trial and focus on the letter of the law.
Absolutely.
What would you say the weakest point in just hearing about some of the testimony and from the prosecution? What would you say would be some of the points that they really went wrong on in this case?
Well, a lot of things stuck out to me in that respect. Obviously, the inconsistencies in the witnesses are very, very difficult to overcome for the prosecution. There were witnesses who contradicted their own statements. One witness stated to the police that he heard one of Mr. Bell's friends say that he to go get my gun, which we've heard from the grand jury testimony of one of the detectives. And then later he says, oh, I didn't really say that, or I didn't mean that, that's not what happened. Mr. Benefield's testimony about multiple strikes by the car was contradicted at trial. He said, we only hit something once. And I don't know why I said that earlier. Yeah, these are very, very difficult inconsistencies to overcome. But more than that, you hear the very emotional, even though it's read on paper, you could feel the palpable emotion of the grand jury testimony of the detectives. These did not seem to be rogue, evil villains. They seemed to be, like in Detective Isnora's case, he stated very clearly that this is the last thing he ever wanted to happen. And if you look at him, I tend to believe him. And in the facts of the case, they don't seem to be people who were looking to have this tragedy occur. That is one of the reasons why it's so difficult to establish these intentional or reckless standards when you have police officers that are trying to do their jobs. They made horrible mistakes. There was carelessness involved, but does it make them criminally responsible? The tragedy that occurs does not necessarily equate to criminal behavior. You can't look at a case as a result-driven process. The level of the tragedy obviously has to be considered, but it can't make somebody criminally liable over civilly liable. It just doesn't work that way.
I was just going to say, following up on what you're talking about, Lisa Calagrassi was saying how Detective Oliver just put his head in his hands and also wept at the verdicts as well. And all along he has been, to use her words, stoic during the trial. But just one more example, perhaps, Mr. Farkas, of that these are, alongside with being a police officer, that they are vulnerable and human beings.
Absolutely, and the system obviously has to be designed to account for that. Everything, it revolves around human beings. Police officers are human beings, they make mistakes. People on the street are human beings. They either make mistakes or they do things purposefully wrong. Some of that may have happened in this case, some may have not on both sides. But these police officers are human beings, and from their grand jury testimony, I think it was a very smart move by the way not to have them testify at the trial. Their grand jury testimony said it all. It couldn't be cross-examined, but I think it was sincere. I think the judge considered that and certainly considered how a lot of the witness testimony was not sincere.
We're going to ask